Hello, everyone. We have now entered Unit 3, which is our biggest unit, contracts. This unit is going to be subdivided into Part 1 and Part 2. Part 1 is what I call the core elements of contracts. It's going to cover offer, acceptance, and consideration. And then Part 2 is going to cover some of the other elements, or sometimes people call defenses of contracts. So, right now, we're going to have a basic introduction to contracts. What is a contract? Why are contracts necessary? The terms used to describe contracts. And then we have two laws that apply, the common law and the Uniform Commercial Code, Article 2 of that code. And I'm going to explain that to you. So what is a contract? A contract is a legally enforceable promise or set of promises. Not every um, promise is enforceable. For example, I could say, you know what, for your birthday, I want to give you $50. And your birthday comes and I change my mind. You would not be able to enforce my promise in court. And we're going to later talk about that. And there could be several reasons. Maybe you didn't accept my promise, but more importantly, you didn't give me anything in return. And that is going to be a crucial element of contract. So just keep in mind what a contract is a legally enforceable promise or set of promises. And we determine how it is legally enforceable by the elements. And remember, the elements are like a recipe, it's what we need. So, why are contracts important in business? Well, obviously, um, you know that businesses need these contracts because it gives us something that we can ensure that we actually have um, predictability in what we're doing. So that's the primary goal of contracts and businesses, so that we can plan. If we do not, if we can't hold somebody in force or to a contract and hold it enforceable, it's going to be really hard for us to plan. But it's going to act also as obligations and hold people accountable for what they say they're going to do. And basically, it allows us to do all these things like alleviating risks, ensuring confidentiality, boosting effectiveness of operations. It helps us to aid overall compliance and adherence to legislation, maintain a strong cooperation and interaction between parties. And basically, it can also help us with our organization's image and philosophies. But it comes down to really two main things. One is it gives contracts give us a way to create private law for governing transactions, and it gives us a force that we can go, wait a second, I can facilitate my planning for my society, and for my business because there's a way to enforce um, someone's obligation to you. So contracts come under two things. They come under the Uniform Commercial Code, um, or they come under common law. And the Uniform Commercial Code basically is a slight departure from common law of contracts. And what it did is we needed a uniform way to look at interpretation of contracts through the state, especially as travel increased and people were doing a lot of business cross state lines. The kicker is the UCC, which basically came, the Uniform Commercial Code is just a list of basically what the law, a bunch of practitioners thought the law should be. Okay. It's not the law itself. However, many states actually have codified, we call it, and they've taken the recommendations. Okay. The UCC covers the sale of movable, tangible goods. Please write that down. The UCC covers the sale of movable, tangible goods. That's going to be your first um, point on your quiz when we're asked for the lecture points. The UCC covers the sale of movable, tangible goods. Your third down here. Okay, it doesn't cover every contract issue that arises, so it may not cover certain issues in contracts, and then we would revert to common law. And remember, common law is what judges over time have established as the law. Okay, so um, for states that have codified, the UCC, meaning they said, you know what, we're going to use this as law for our movable tangible goods. If it's not something, an area is not covered, then you look to the common law. Kansas has codified it, and it's under Chapter 84 of our statutes. So remember, you can go to your reviser of statutes, and it's going to tell you all of the different articles that you have. Chapter 84, all the chapters. Chapter 84 is the Uniform Commercial Code. Okay. So again, if you were in Kansas, you would go to Chapter 84, which is the UCC, if you're dealing with movable and tangible goods. And this is going to be less strict than common law. So what do I look, when do I use common law? I use common law when I'm dealing with services, right? Because it's not tangible. I can't touch services. Real estate, because real estate is not movable, and intellectual property, because that's not tangible. So that's when I would apply common law. We're going to talk more about this in depth as we get into the differences of the laws, depending on what we're talking about, real estate versus a tangible, movable good. But you need to know kind of this background here. So we're going to talk about contracts having elements, and the elements are going to be offer, acceptance, consideration, capacity, consent, legality, and writing. But not all contracts have to be in writing, only some. This first section, we're going to just talk with offer, acceptance, and consideration. Okay, now what I want to talk about is some just general overall definitions of contracts. First, bilateral versus a unilateral contract. A bilateral contract is where parties exchange a promise for a promise. I will buy your car for $500. You are going to sell me your car for $500. Once we've exchanged this, it would be, if we have the elements of a contract, that would be a bilateral. A unilateral is, I don't want you to promise me something. I want you to do something, and that will make a contract. The most used example of this is a reward for a lost dog or something, right? I put a poster out there, I've made the offer, but the only way you can accept is to perform by giving me the dog, my dog, then I'll pay you. I don't want you to promise me you'll find my dog. I want you to give me my dog. So that is a unilateral. It's where a party gives a promise and the other party performs, and that becomes a contract. Bilateral is a promise for a promise. Here are terms we're going to need to know, and we will need to know those as we talk about some of the elements that come down when we're talking about capacity and consent and things in writing. But I want you to kind of just know the key concepts. A valid means we have the basic legal requirements for a contract. Unenforceable. Okay, so a contract that meets these basic, but they may not be enforceable because of other reasons, most commonly the statute of frauds. So we may have a valid contract, but it is going to be unenforceable by the courts if it's required to be in writing. Void. Void is illegal contracts, and those that create no legal obligation and they have no legal remedy. And then we have voidable. And we have a voidable contract if one of the harm parties have the right to cancel, meaning I'm able to void. It has a legal obligation, but one party is able to void it. Express versus implied. Express contract is we have directly stated what our intentions are and that we are in agreement. Implied is we can basically imply, because we both acted in a certain manner that would show that we actually have a contract, but we didn't really necessarily express the contract. Executory is parties have not fully performed. So I'll buy your car for $500. You'll sell your car for $500. I may have given you the $500 and you haven't given me the car, or neither of us may have performed yet. That's executory. Executed is where both parties or all parties have done everything they need to fulfill their contractual duties.